Good afternoon, everyone. Happy Sunday. Welcome to another episode of Spilling Tea. I'm your host, Tiffany Daniels. And we are going on further today into our Advanced Directive series. And today we're going more in depth in regards to living wills. And of course, what you see on the screen here, you'll also see a direct link to it in the description box, which reminds me we're going to get to the disclaimers. Not just this one, but for every single piece of information that we go over throughout this Advanced Directive series, you're going to find all useful and helpful links right there in the description box, not just for the information, but also within those links you should find access to be able to start the process of getting your own Advanced Directive set up as well, should you like to do so. So, you're welcome to do so. That's why I always include those in the description box. Trigger warnings. Now, we do have the channel marked not for kids because I use a lot of profanity. A lot of profanity. And there are some subjects that we cover on this channel that can be it can be very triggering. Sorry, the word escaped my brain there. So if you have a child that is 16 and younger and they're watching the channel, parental supervision very obviously is advised, all right? Also, trigger warning, I very obviously have a very sudden case of allergy suck syndrome. So you might see weird clearing of the throat. I may sneeze and see that it's not edited out. A, that's because I don't know how. B, it's because I'm lazy and I don't want to have to continue to do the same video over and over and over again till there's a moment where my allergies aren't killing me. So apologize for all of that in advance, alright? Okay. Living will, definition, purpose, and how to make one. And of course it's from Investopedia. But let's get into it. What is a living will? A living will, also known as an advance directive, one of the many, which is why I use the umbrella term for the series, is a legal document that doesn't specify the type of medical care that an individual does or doesn't want in the event that they are unable to communicate their wishes. So this is very much end of life treatment, but considering our current government and the way it is acting right now, having that in place just in case, yeah. Key takeaways. A living will is a legal document detailing the type and level of medical care an individual wants to receive if they are unable to make decisions or communicate their wishes when care is needed. A living will addresses many life-threatening treatments and procedures such as resuscitation, ventilation, and dialysis. A person can appoint a healthcare proxy to make decisions regarding the care when they are unable to do so. So I have both living will and durable power of attorney, which has my mom as number one on each, but each one also has the same backups as well. Always good to have, particularly if you don't have children, like myself, who won't be able to take that position. Those of us who have to choose older relatives, like our parents, for example, it's good to have backups because as I get more and more middle aged, my parents are getting older. So keep that in mind as well. If that situation is also like you may want to make sure that you've got a few backups set up as well. A living trust is a legal document that addresses how assets of the incapacitated person should be managed. People can enlist the services of an estate planner or an attorney to help draft or review a living will. Now, that has more to do with people with estates and a whole lot more money than you and I. What we're primarily going to be really focusing on is the main intention of the living will. Your end of life decisions in regards to your care is what I would say, as of right now, is most pertinent. Now, I'm not going to tell you don't study up on the other side. Definitely, if you need to, go ahead and do so. But I'm saying my primary focus throughout the series is specifically for living will. The end of life decisions in regards to overall healthcare is primary concern number one. All right, so understanding a living will. Living wills and advance directives come into play only when an individual faces a life threatening condition and is unable to communicate their desires for treatment. Every state provides for the drafting of a living will, although some states call the document a medical directive or healthcare proxy. Now, the difference between this and durable power of attorney is that durable power of attorney, it doesn't matter whether you are terminally ill or not. If the state, for any reason, declares you incompetent, for example, if they try to tell you that you are too disabled to make these sort of decisions in regards to your health care. And as of right now, that is my primary concern. That is one of the number one things that I am 100% the most paranoid about, especially in regards to the Medicaid cuts. It's not looking good, folks. We're talking about a very quickly spiraling situation once everything comes to an effect. So, what that durable power of attorney does is if the state declares me for any reason to be incapacitated, unable to make those decisions legally for myself, then you see how that automatically clicks in? And I have it filed with the state, as well as my mom having a copy and me having a copy. So, if, for example, they declare that I am too disabled, too incapacitated, and they try to send me to some state facility against my will or wishes, well, because they declared me incompetent, because I have that durable power of attorney in place, they're not going to be able to do so. They're not going to be able to force me to go and do anything without my mom's express consent. Now, living will is different. It is literally resuscitate or do not resuscitate. Or if you are incapacitated, like you are literally brain dead, and there is, through medical science, no technology even remotely on the horizon that looks like it may be able to wake you up someday. And that sort of thing, whether to keep the life support on, that's one of the things where a living will would come in. If you don't want to be incubated or put into ICU, that's another thing you can do with living will. It gives you the ability that if there doesn't seem to be any form of treatment that's going to get, you can choose hospice. You can kind of see where I'm going there, right? This is literally has to do specifically with you detailing what you would like your end of life health care to be. Some states let you prepare a detailed, customized living will, while others require you to fill out a standardized form. My state is one of those standardized form areas, but that doesn't mean that I still didn't get my details in. Folks, state or federal government, get your details in. Everything you miss to put in there, the state or Fed will deny you. Trust me on this. Details, no matter how insignificant they may seem to you, put it in anyways. Always better to be over-prepared than under-prepared. Now, what is included in a living will? Let's go ahead and go over this real quick. A living will addresses many of the medical procedures common in life-threatening situations, such as resuscitation via electric shock, like defibrillator, for example, ventilation, like I just said, and dialysis. You can choose to allow some of the procedures or none of them. You can also indicate whether they wish to donate organs and tissues after death. Because, in particular, this part is important. This is something that the mainstream public doesn't really know. Is if you are on the donors list, sometimes in order to harvest certain organs, they have to keep you at least somewhat alive so that they can be able to extract the organs in the most healthy, sustaining way possible. Like the quicker they can get to those organs, the better, sort of thing. So they may need to keep you alive to keep those organs alive until they can complete harvesting them properly. If that's something that sounds utterly horrifying to you, that might be something you might want to mention as a detail in your will, that you don't want to do that and that you would like to be a donor but would prefer it to be done after you had fully passed. Or if you still want them to go ahead and do that, you can put stipulations in, like I did. Like, if I'm even like somewhat coherent, like, do what you need to do, drug me up to the gills. I need to be able to talk to Elvis, J.R.R. Tolkien, and Spartacus. Kind of drug me up and do it, Doc. Right? Even if you refuse life sustaining care, you can express the desire to receive pain medication throughout your final years. So if it's a terminal and you're not wanting to try and fight it, but you don't want to suffer the after effects either, you can include that in your living will so that you can continue to receive them, right? Even though you yourself are incapacitated. It's a very, very, very important thing to have, especially if you're disabled. And it doesn't matter what kind of disability you have or how benign society tells you it is. If you've got anything that even remotely looks like a label, get this set up, get it set up now. In most states, you can extend your living will to cover situations where there is no brain activity, like what I just mentioned before, for example, or where doctors expect you to remain unconscious for the rest of your life, even if a terminal illness or life threatening injury isn't present. Because these situations can occur to any person at any time, at any age, it's a good idea for all adults to have a living will. 110%. I agree completely. Now, how to make a living will. We're going to kind of read through this here and just kind of comment like we have been. Sorry, I was going to say read through it fast, but those have been like famous last words lately. Before making a living will, it's best to understand that it will not serve as a last will and testament, where property and personal effects are allocated to others upon death. One has to deal with specifically medical situations. Some financial stuff, yes, but that has to do with maintaining your estate, maintaining your home while you're still here, even though you may be in your final years. An actual final will and testament is only for after you passed. So it has nothing to do in regards to any decisions being made in regards to your medical care. It can't be because you're dead. A living will stipulates the type and levels of medical care you receive if you're incapacitated and how long you will receive that care for. When creating a will, considering how you want to integrate your personal or religious beliefs into your care you receive. So, if religion is important to you, especially when you're doing a living will, make sure you get that in there. Make sure you get that in there. Like I said, every detail, even details that you would think wouldn't matter, put it in anyways. It might be helpful to segment the living will into categories of care. You can first identify the circumstances in which care should be extended to preserve life and what types of life saving or preserving care, such as blood transfusions and dialysis, should be administered. See what I mean? Go into detail. Another category to consider is pain management. Indicate the types of levels of treatment to manage pain. You can further break down this category into life sustaining pain management and pain management in lieu of life sustaining care. If you have family or friends who will be responsible for overseeing your care, discuss your plans with them, which I already have multiple times. My mom started having that conversation with me as a healthcare person, literally been in healthcare over 40 years. We had that conversation early, early. And we talk about it again from both of our sides as we continue to get older. So, if you haven't, start doing it now. It might be helpful to include them in the decision making process. My mom always is. Always included or informed, as they might have insight into areas otherwise overlooked when planning alone. Lastly, enlist the help of a professional, which is what I did at the workshop. Thank you, old job. I love you, my old director. Such an estate planner or an attorney. These experts can help you make decisions for the best possible outcomes. Healthcare proxy. In addition to a living will, you can select a healthcare proxy who is allowed to make decisions if you are incapable of making those choices. Some states call this individual a healthcare power of attorney. Living wills cover many medical decisions, but a healthcare proxy can consult with the doctor on other issues that may arise. When facing the loss of a loved one, families often disagree over treatment, so having a healthcare proxy can reduce confusion over your final wishes. You should discuss wishes with the proxy before naming this person and be sure the proxy is willing to follow through with your desires. There's a very specific reason I chose my mom, other than her being my mom, and it's because she's been in healthcare for so long that I specifically chose her because, in spite of her being my mom and emotionally attached, I know for a fact that she will make the decision to pull the plug if it's in no win situation, a brain dead, only alive by machine type of situation. So, it's one of the main reasons specifically why I chose her, because I knew she would respect the decisions that we set down together while planning that out. Well, I had the workshop, yes, and they did allow me to add in details later. A living will involves how you will be cared for if you're in a compromised or incapacitated state. This is a medical directive terminates upon your death. And where I altered it, weirdly enough, you gotta love doctor's offices that are near your lawyers. Just say, made at least that part of getting the paperwork done a lot easier. Living will versus living trust. Although a living will and a living trust are different, a living will involves how you will be cared for if you are compromised or in a capacitated state. This is a medical directive terminates upon your death. A living trust deals with the property and assets of an incapacitated person. The trust essentially becomes the new owner of the assets, so it manages all your home finances. Under the living trust agreement, a trustee or the person or persons responsible for managing the assets is identified. I never had one of these because I'm doing well now, but I don't have multi-million dollars that I need to be concerning myself with. But there are some who may have something or they may have an inheritance to deal with. Just as living will deals with a living person. A living trust deals with the assets of a living person and protects them. They are both executed when the initiator lacks the capacity to make decisions for themselves. This also protects you from the bank just starting to make random decisions because they haven't heard from you. Do I lose control of my living will if I appoint a proxy? You will not lose control of your living will while you have the ability or capacity to make decisions. If incapacitated, the proxy has legal authority to act on your behalf, making decisions about your health care. That's why when you choose your proxy, you better make sure 1,010% that they are 100% on board with you with everything. Whatever changes you make, like I did, the original paperwork, everything. Everything. Okay? Review the living will with the proxy to ensure they understand your wishes and agree to enforce them when needed. What is the difference between a living will and a last will and testament? We already went over this a little bit, so we'll go ahead and bypass it. What is a bank's living will? A bank's living will is a legal report filed annually by companies instructing how the business will be liquidated in the event of insolvency. Banks with at least 50 billion in assets are required to file a living will with regulators. No wonder I've never heard of it. Anybody want to give me 50 billion so this can suddenly become a problem for me?